In previous videos, we saw how default distribution rules under the probate code can change depending on the timing of a person's death. In one scenario, all the grandchildren got equal 16% shares of an estate, while in another scenario, only one child had predeceased and the surviving grandchildren got a smaller share. If you are the personal representative for a person who passed without a will, we can explain to the survivors how state law decides their shares of the estate. Now look at another situation controlled by the timing of a person's death. In this example, child 3 passes away 1 minute after his mother. His full 33% share will pass through his estate to his child, while the children of child 1 still get 11%, a third of a third. In some states, there is a requirement that a person survive for days or weeks after the death of a person who leaves an estate. Not in Massachusetts, though. Here, it doesn't matter whether a person dies a minute, a week, or a month later, the per capita share stays the same. But with a will, you can set time requirements for survivorship and decide how your estate will be distributed. With additional estate planning, you can avoid probate entirely. Let's simplify the example to show what else can happen when there are 2 children and only one child survives. The surviving child, child 1, takes 50%. The child of child 2, who predeceased, gets the remaining 50% per capita share. What do you think would happen if child number 1 decided she wanted to increase her family's share by disclaiming her 50% interest? Disclaimer of an asset is allowed by the probate code. When a person disclaims their right to an asset, it passes just the same as if the beneficiary had actually died before the event that made her a beneficiary. In our example, the disclaimer sets up the per capita distribution rules that we talked about in the previous video, meaning that the 3 grandchildren here would divide the entire estate equally, each taking 1/3 shares. Child 1's 2 children would get 33% apiece, a total of 66%, instead of the 50% that would have been distributed to child 1 if she had not disclaimed. Is a disclaimer allowed in this case? The answer may be no, since the probate code says disclaimer can't be used if the result would substantially impair the provisions or intent of the law. When a person doesn't leave a will or trust, important questions are raised and the answers are left to the probate code. Call if you would like to make a plan that gives specific instructions on who benefits from your estate.